topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
The experts, where we bring you the finest experts in the field of legal, health, financial, and home improvement. I got to tell you, today is one of my favorite shows. But I got to tell you this, I'm having so much problems with my computer that we're having to do this by phone. If you are watching today, I think you'll still be able to watch our great expert, Alan Swartzide of K. Bender Rimbaum. We're going to get through this, folks. We wanted to make sure that we gave you a live show. The only problem with a live show is if you've got problems, you've got problems. So I think we're going to be able to get through this. I've got a professional on the other end with attorney Alan Swartzide. Hi, Alan. How are you?
Doing all right. Thanks, Steve. Glad we could make it at this point. It was a harrowing experience, but like you said, consummate professional. I just sat there and we figured it out.
We did it. Did you make it through Passover?
Not yet, because it's not over yet, but I made it through the Seder. I have not
That's
broken.
what I'm talking about.
Yet. I'll put it that way. I don't make any promises, but I'm doing my best.
Well, Alan, I'm so glad you're on with us today. Hey, we are scrolling right now, if you're watching on TV, the different classes. Whoa, you got a lot of classes between now and May, the end of May. We'll be going over those during the show. If you'd like to call in, the number here is 561-623-9429. Juan, will they be able to call in today with me being on the phone?
Nope.
Juan? Okay, so what you're going to have to do is I've got your text messages. We've got so many great questions. You can also go to our board, our chat board, to ask your questions. But let's go ahead and get started. Alan, tell everybody about K. Bender Rimbaum.
Sure. Well, we're a law firm, and I'll be a little shorter than I usually am because I know we're a little short on time. Want to get to everyone's questions. We're a law firm that's been doing nothing but representing community associations since the 1990s, 21 attorneys, 4 offices. Mine is located right here in Orlando, currently right next to UCF, about 3 minutes away from campus. So just anything that a community association needs, that's all we've done for years and years, and it's all we continue to do. And, like you mentioned, we've got 8 million classes coming up. My friend Jeff was kind enough to send apparently only the ones that I'm teaching, because all 4 that are scrolling across the bottom are my classes. But we will get into some of the other ones. But we think education, including being here with you today, Steve, is just really important that, people get the answers to their questions, because frankly, a lot of people just are, I'll be blunt, they're not capable of paying an attorney to get a fairly straightforward answer. I can't promise straightforward answers today. I don't have your documents in front of me, but I'm going to do my best based on what's in Florida law.
K. Bender Rimbaum is all about education. You guys give up so much of your time free. You give up your time to educate people. And when it comes to HOA Condo Community Association, it is so important because things change sometimes by the day. I look at the questions that come into the show, and People have so many questions, and this is a great outlet for them, Alan.
Yeah, I agree. I mean, you talk about things change day by day. Literally, I think one of the first condo and HOA bills that we were expecting to come in, and I know I said I didn't want to talk a lot about what is coming down the pike, but there was one. The My Safe Florida Condo Act was just signed into law yesterday. So it doesn't go into effect, I think, until July 1st. But that's step one towards letting everyone know and educating everyone as to what those changes are going to be this year. There's always a slew of things that the legislature throws at us, so we just have to hope they don't hurt us too much. But that is, this one is actually a helpful program. So I don't want to go into too much detail. I'm sure, I know that my partners, Mike Bender and Jeff Rembaum, have had one or two classes on what we think is coming down the pike. But I'd rather, save that for, I know I said last month, hopefully next month. I'll say it again, hopefully by next month. By the end of May, we'll know what the heck's coming up a month from then when these laws start to go into effect July 1st.
So the governor signed off on one of those bills finally?
Yeah. The My Safe Florida Condo Act. And that is, if I recall correctly, and frankly, I haven't read through it in probably 2 to 3 months, but if I recall correctly, that's the program that's going to provide funding for safeguarding your buildings in a condo. And I think it's, if it's the one that I'm thinking of, it's a fantastic law because realistically, one of the most dangerous things that happens here in the state of Florida, except Floridians, is a hurricane. And so, hopefully this will be something that helps some of these condos that have been, as we've been discussing almost nonstop, have been concerned with their ability to safeguard their communities and do the things that their structure needs. Hopefully this will be one of the things that helps them contribute to not having to come up with all of the money for some of these things, but it'll be specific to hurricane protection, storm protection.
Gosh, I read where there's some kind of a formation already out in the Atlantic. Look how early it is.
Yeah, I know. And that's why I said, other than Floridians themselves, I think hurricanes are our biggest concern, our biggest danger. But let's hope that everything goes back into the ocean and just makes a U-turn.
Absolutely. Well, I'm going to get to our chat board.
All right.
A lot of our favorite listeners and viewers are already up there with their questions. We'll start off with Karen. She wants to know, can a condo board not have any open meetings from May to November? That's her first question. There are four board members who do not go up north and they stay here.
As of now, I'm not aware of anything that requires you to have a board meeting in a condo. I think that's one of the statutes that's being considered right now. But when you say, they're not meeting from May to November, as long as they've put the requirements in place and delegated the authority to take care of what's needed to, basically do what you need as a condo to properly operate and maintain the condominium and the community itself, I don't see a big problem with that. I'd rather have them meet in an open forum. What concerns me is the implication that they're meeting in a closed forum, whether that is something that they can do in a closed setting or not. But bottom line, most of the time, if you have a manager in a condo, the manager's taking care of most of that. They're just taking direction from the board that they might have said, okay, over the next few months, this is what we think is going to be needed. And if they're not meeting over those 6 months, then you have two options. One, you find out whether anything is being done, what's being done by the condo, and you decide whether you want to try and get on the board when they have their next annual meeting. Whether that's an option or not for you, I don't know. But, anytime someone is saying, I don't think the board is doing what they're supposed to do, my answer to that is, okay, get on the board and make sure they do.
Alan, I see why you get so many letters during the week. People love how you explain everything to everybody. We are so lucky to have you. We're going to go. Don't let that go to your head now, okay?
I'm trying. No promises. If you see my head start to fill up the whole screen, just know we're going to have a problem.
Yes, I know. Let's go to TBC board. If an entity is interested in buying the condo building property for development, what is the board's responsibility to notifying the owners?
Well, I mean, there are a couple different issues there. If you're saying they're interested, the board doesn't have any obligation to say there's a corporation that's interested in buying this up. It's when you're actually contemplating saying yes that you need to really think about that. But if you've got a condo building and the consideration is that a corporation might buy it to develop it, that implies to me that you're talking about a potential termination. And that is definitely something that involves the members, involves a member vote, involves paperwork, possibly a court. So, what you're looking at is, are they just interested or have they made a proposal that the board is actually considering? It's at the point that the board might actually consider a proposal that you really have to notify the members.
Got you. Let's go to Gabe in Orlando. Alan, we get so many letters regarding parking, and a lot of them about parking. In the 60s, usually most people only had one car. But now with, 2 and 3 bedroom condos or houses, people have 2 or 3 cars.
Right.
And it makes the parking so hard. So here's Gabe in Orlando. We don't have enough parking. We have a 3 bedroom condo that have 3 different people living in it, and all 3 have a car. What can we do about our parking problem?
Well, one thing I've seen, especially in like the downtown Orlando area and other, really metropolitan areas, you're talking about Fort Lauderdale, Miami. If you've got, public parking or parking that is paid, you might have your condo try and work something out with the company that owns that parking lot. You might be able to have parking where, you got to walk across the street, but it's better than trying to find something when you come home from downtown Orlando at midnight and you're trying to figure out where to park. The alternative, it depends what common areas, common elements exist in the condo right now. If there's a bunch of open land that you're just doing nothing with, or common elements that aren't being used, I hate to give the example of like a tennis court or something like that, which, let's be realistic, right now it's going to be switched over to pickleball if it's not being used. But if you've got open space, you can potentially have a member vote to adopt that space as using it for a different purpose. It just comes down to, what do you actually have available? What are your resources? And if the answer is we got nothing that we can use for this purpose, we're just short on parking, then you might have to try and find a deal where you work something out with an adjacent community, an adjacent parking area, or, like I said, just something that's within reasonable walking distance. Just be careful of the issue when it comes to, saying reasonable walking distance, but then someone actually has a disability or a handicap and they can't walk that far. But that would be, unfortunately, the best I can give you is look and see. The other thing is you might consider having the parking designated for individuals so that everyone does get at least one spot if you've had it first come, first serve in the past. Unfortunately, there's not a whole lot more we can say about what your options are. That's pretty much it, unless there's some really creative solution that I don't know of because I don't know your particular condo.
Okay. This next letter is really, I think it's unusual. I've never heard this before. It's Jill in Orlando. Our condo association pays a management company $28,000 a year. And this is the part I don't understand. We paid the past president $35,000 a year as a liaison. We have 75 condos in our association. Is this legal? I've never heard of a past president being paid that kind of money as a liaison.
I haven't either, and I don't know what liaising is needed to justify paying the past president more than you're paying your manager. I can't necessarily say it's illegal. It might be provided for in your governing documents. The other thing is, you mentioned that it's a past president, so it's not a current director. Depending on what task this person's actually doing, they're technically just a vendor to the association. I'm not saying it's okay, but that, frankly, I would suggest that you run that situation by an attorney. It won't be me, because that's generally not something our firm deals with. But if you want to reach out to me directly, my email is as@kbrlegal.com. I'd be happy to suggest a couple of attorneys here in the Orlando area that might be able to take a look at it for you and give you a kind of the rundown of what your rights are here and what the association and its members might do to stop this from happening if in fact it's improper. I don't want to say that all of us automatically this is wrong, but it doesn't pass the smell test is the way that I would put it.
Or you can call Alan. He usually takes calls around 2 a.m. if you've got a question like that. Yeah. I'm kidding. Please don't do that.
If you're calling me at 2 a.m., please call the office. I'm not giving out my cell number because then I don't have to pick it up.
Alan, I had a friend tell me that he's a mayor of a smaller town, and he said he got a phone call at 2 o'clock in the morning, and they said the street light is shining in their face, and they can't sleep. The next day, he called back at 2 a.m. in the morning and said, "I got it fixed for you." That's a good comeback.
That's good. I like that.
Anyway, I hope that. Yeah, I do too.
That's what's happening for any client that calls me after probably 9 o'clock at night. Expect to call the same time the next night.
Very good. Let's go to Vince in Orlando. What does the Architectural Review Committee do? Are they more powerful than the board?
So the answer to the second question is no. The board generally, unless your governing docs are written weirdly, that's not a legal term, it's just the way that I'm going to put it. Generally, the board has power over the architectural committee. Now, what that architectural review committee is generally going to do is use the guidelines that they've been given by the board, which is why I say the board generally has more power. They're going to use those guidelines to decide whether or not an architectural modification should be allowed. What I mean by that is if you want to change the appearance of your lot in any way, shape, or form, and the association has something in writing regulating that type of change, this architectural application should be completed and submitted to this architectural review committee. And they're going to decide whether the answer is yes, you can do what you're asking to do, or no, I'm sorry, but this doesn't fall within our guidelines and it's not going to be allowed. So that's essentially what that committee does, is decide on changes to a property.
Before we go to your upcoming schedule, let's go to Barry. He's always got great comments. He said, if a condominium does not waive their 2025 structural integrity reserves, unless they start funding their reserves in 225 or 2026.
If they don't waive reserves, then they need to start funding probably in 2025. If they waive them, they might need to start in 2026. And in reality, they should be funding them now.
Very good. Okay, now the part of our program everybody loves to hear. Give everybody your schedule for your classes.
I know it's exciting. All right. Well, I'm here tonight. We've got tomorrow, I'm actually doing a board certification class for HOA board members. That's on Zoom. It's available to whoever wants to join at 11 in the morning. I've got a board member certification for condos on the 30th, which is next Tuesday. We have a lunch and learn at Capriccio's. That's not a local one. So if you're listening from South Florida, that might be one to check out. You can see all this at kbrlegal.com on the event calendar that's linked at the top. We have Ask the Experts for the Tampa market on the 30th as well. And then in May, we've got Ask the Experts down in South Florida on the 3rd. I'm doing another webinar. I know it sounds like I'm the only one involved here. I promise that's not the case. You're just here for the Orlando show. On the 9th, I'll be doing milestone inspections and structural integrity reserve studies. That's going to be with True Property Inspections. So we'll have some of the experts in that physical field, not just the law, that are actually there during that and can add some of their thoughts from personal experience. And then the next one that's in line is the Orlando Condo and HOA Expo, where I'll be teaching 2 classes in person. I think it's covenant enforcement and the legal update, but I'll be there all day. We'll have a booth there, booth 412, and that's going to be on May 21st. Another panel discussion on Zoom on the 23rd. Frankly, I don't even know which one of us is going to be there. And then I have another HOA board certification on the 24th. And we've got a couple others coming up in addition to the Orlando Ask the Expert show on the 30th. So it's for right now, I think I'm doing about a third of what we're doing for the month. But the good news is we're always adding more classes. So check out the calendar, see what we've got coming up, and you can register directly from the website if you're interested in any of those classes that are coming up.
See how when you're a great attorney like you are, they want you to do everything. It's just the way it works.
For everyone else.
Let's give it. You've got locations in Orlando, Tampa, and South Florida. You really got Palm Beach. Give everybody the number if they'd like to contact your office.
Sure. So I know you talked about our reception before, and you will reach them, and you can reach any attorney or any paralegal within the office. It's 954-928-0680 or 800-974-0680. And again, my email address is, I'm sorry. My email address, which is one of the easiest ways to reach me because it doesn't matter where I'm at, I can usually respond, is as@kbrlegal.com. You've also got my name here. Feel free to follow me on LinkedIn, where I try to post something helpful to community associations, managers, and just the industry as a whole at least once a day.
You can always find Alan at Chuck E. Cheese. He's usually there late at night. We're going to go to break.
All right.
We're going to get to all your questions. We got tons of them. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. We're with you every week, every Thursday, 5 o'clock. I'm your host, Steve-O. This is one of my favorite shows to do. We have attorney Alan Swartzide of the K. Bender Rembaum firm. We got to get to our chat board. We got a lot of people writing. Let's go to Kelly. As an owner, can an insurance agent for HOA state he cannot answer my questions or send me the policies unless the board advises he can?
Yeah, you don't have a contract directly with that insurance company. The association does. So you can ask the association for a copy of the policy, and if they have it, they should provide it to you. They should have it, by the way. But that insurance carrier, that insurance agent doesn't work with you. They work with the association. So that, frankly, it's one of the few instances where I'll say that was totally appropriate for them to not communicate with you. And I'll be also fully clear that the Florida statutes also explicitly say that you don't have the authority to act on behalf of the association just because you happen to own property within the community.
Okay, let's go to Oaks and Countryside. Is there a general timeline, i.e. months, that have to pass by when an owner has not paid his monthly HOA fee until an HOA can put a lien on the property in order to collect what is due?
So there is, but it's not just a number of months. There's a statutory procedure that has to be followed before you can place that lien against the property. Essentially, you need to look in your governing documents and see when it says a payment is delinquent, because there's a difference between, and when I say you need to look, your attorney should be looking, not just the board. But there's a difference between when a property is past due versus when it's actually delinquent. When it's delinquent, you can start the collection process. Some communities will wait 60, 90 days. My perspective is if someone's not going to pay on time and you can't charge attorney's fees for the first letter you're sending out, send it out right away once you can. But that's the board's prerogative. Usually, my strong recommendation is that every community in Florida has a collection policy in place that says exactly when you're going to start this process and how you're going to proceed through it. But getting to the actual statutory process, once you know you have a delinquency, you can send what's called a notice of late assessment. That's basically going to be a letter that goes to the owner and says, if you don't pay within 30 days, all these amounts that we're saying are due, just understand that we're coming after you and we'll send the next statutory letter. Doesn't really mean a whole lot. It's really just a relatively new thing that came out about 2 years ago, and it's intended to give people the opportunity to resolve this delinquency before they start spending attorney's fees and costs. The next notice is going to be the last one you have to send before you actually file the lien. That's called a notice of intent to file, notice of intent to record a claim of lien. And what it really says is we're giving you another 45 days before we're going to go ahead and record a lien against your property if you don't pay the full amount that's owed to the association. So again, there's no specific time frame, but chances are you're not going to get this done within less than 90 days because there's a 30-day notice and a 45-day notice that must go out before you can really record a claim of lien. So if there are any other questions, we do have a full class that talks about this statutory process. It's just the collections, should I pay or should I go? And we do have copies recorded and available for pretty much any of our webinars that we've done are up on our website at kbrlegal.com under the resources tab. You can look at the past videos. And hopefully that answers the question. Again, if there's anything else, collections where I started in this industry, so it's kind of my thing. So if you want to give me a call or shoot me an email, I'm happy to help.
So I have a stupid question.
I doubt that.
So I know this is probably stupid. You know, you're not supposed to give legal advice. Board members, it's got to go through an attorney. How are they doing these classes? Those aren't taught by an attorney. And somewhat, these classes, aren't they giving out legal advice? Because I heard these new classes, you don't have to be an attorney.
So if you're talking about the board certification classes, there are some other people that have been qualified by the DBPR to provide them. My perspective is getting a class from an attorney is the best way to go because you're most likely to get legal analysis, even if it's not legal advice. But there are people who have been designated and authorized by DBPR to go ahead and give those classes, even though they're not attorneys. Some of them are fantastic. Some of them are terrible. I'm not going to name names, but the bottom line is I'm not giving legal advice, even when I'm doing a Q&A session, just like we do on your show. I'm not giving legal advice because I'm not talking to a client. I'm not talking to someone whose documents I'm looking at. I'm talking in general terms of what my experience and from my perspective, what the law requires. Now, if they're saying this is what the law says, that's a problem. But if they're saying, in my experience, this is how it's been handled, that's not legal advice. Okay, there's some risk to the person that's teaching the class that the Florida bar might disagree with that statement. But my perspective is you're going to do better and probably get more legal information from an attorney. What I would actually suggest is take it with an attorney and then take it with a CAM. Because a CAM that's been in the industry for a long time is going to understand this stuff and understand the day-to-day better than a lot of attorneys. They may not understand the law, but they understand the practical aspects of some of the things that attorneys just don't get asked about. So I would suggest you do it with both. But Steve, to answer your question, they're not giving legal advice unless they're doing it wrong.
Okay. Yes. Let's go to a second question, one from Kelly. HOA, thank you for telling us that. Can a past president who has obtained a new CAM license become our new manager of our association for fee if the rest of the board allows this? We need a new management company.
Yeah, I don't see any problem with that. It's a past director. As long as it's not a current director who's the manager. I mean, the fact that someone volunteered to serve on the board, frankly, that's probably going to give them a lot of inside information as to how to best manage your community. I don't have any problem with this whatsoever. Now, if they try and get back on the board and stay the manager and be paid for it, that's a conflict of interest. That doesn't mean they can't do both anyway. They might not be able to. I frankly don't know whether there's a specific law. I know you can't have the same attorney representing the management firm and the association. I don't know whether there's a specific law that says the CAM can't also be a director for an HOA. But there's definitely a conflict of interest there that would have to be disclosed. There's a supermajority vote of the board. There's a vote of the members that can be taken to cancel the contract. Frankly, from my perspective, it might be easier to go with someone who's not going to ever want to be the manager, be the president or a director or officer again. But unless they become a director or officer, I don't have a problem from a legal perspective with having them serve in that new role. My concern is when you say they just got their license, I hope that they just got their license and they're working with a management firm. Because if they just got their license, they might not know everything they need to know to properly address your needs.
Let's go to Floyd. We have a small 4-unit commercial condo. We have 4 board members, 1 per unit. Can a board vote on his or her violations?
No, that's a conflict. That's one of those, no, I'm sorry, you can't vote that we don't go up against you. It doesn't work that way. That's a conflict of interest, and that person should be abstaining from that vote. Hey, we finally got a straightforward answer for you, Steve.
Okay, this is from Germa. If one lives in an HOA that is also governed by a POA, and each community has a representative that sits on the POA, annual meeting is the POA not required to send notification to all homeowners?
So to simplify this a little bit, we're basically talking about a master and sub relationship when it comes to these two communities. The answer to the question of whether each member in the sub is due notice of the annual meeting will depend on whether the subs themselves, meaning the actual associations, are the members of the master, or if the individual unit or lot owners are the members of the master under the master declaration. If the individual unit or lot owners are the members themselves, rather than the associations being members, then yeah, you would be entitled to notice. But if you have a situation where you've got a master and 6 subs, and the 6 subs are the members of the master, and some communities are laid out that way, then generally speaking, that representative might be the only one that gets notice and gets to vote as to who is on the board of that master association. So it really just depends on what the master documents say.
Okay. This is a follow-up. HOA and POA Can the same law firm represent both in a conflict with a homeowner in the community?
I don't see any reason why not, unless and until they're both going after this owner and their rights start to interact in a way that one moving forward with what they're asking for is going to hurt the other. That would be a conflict. But saying, yeah, we represent a master and a sub, and the master and the sub are both enforcing violations against this owner, I don't see that as any kind of conflict at all. The only conflict you'd have is in collecting the attorney's fees and costs that you're spending if the owner isn't fully collectible for both debts. But the bottom line is, I don't see a conflict there. Both communities presumably have the same interest, unless and until you come across a situation where one enforcing its rights impacts the other's ability to enforce its rights.
I'm going to go to Sylvia in Orlando, and we get a lot of questions like this. What can I do if the association isn't keeping up with maintenance? I thought that was in our docs, that the association must take care of this, also with landscaping. We get a lot of letters of people saying that their lawns not being taken care of, bushes, landscaping. What can a person do, Alan?
Well, step one is to notify the association that your opinion is they're not doing what they're supposed to do. If they're not made aware of it, yes, I agree that if your governing documents say that they're supposed to maintain X, Y, and Z, they should maintain X, Y, and Z, and it shouldn't take a letter from you for them to realize what they're supposed to do and simply do it. But these are all volunteers that are walking into a room and trying to make the best decisions they can. So my suggestion is send something to the manager. If you're not managed, send something to the director saying, hey guys, I know you're busy. I know you all either have jobs or whatever the situation is, or just ignore that and be blunt about it. You guys aren't doing what I think you're supposed to do under the governing documents. Let me know when I can expect that to be resolved. And if it's ignored, or they tell you, well, it'll be resolved when we have money and that'll be in 5 years, then you might want to consider talking to someone about what your rights might be. Sometimes it gets to the point where you really do have to move it forward in order to get the association to do what it's supposed to do. How and when you move that forward, that's up to you. I would suggest that there are a lot of really good attorneys in this Central Florida area that represent homeowners and can give you guidance on that. It really just depends. If you're talking about, they're not maintaining the landscaping, I don't know what you would really want to do and whether you would want to pursue litigation and spend all that money when in reality, how much is it impacting you financially for them not to maintain that landscape? But if you think it's that important, I'm not saying you shouldn't talk to an attorney about what options you might have. It just won't be me.
And this is going to be our final question. This is Connie in Orlando. If we have money left at the end of the year, can we put it into reserves? I think it should be given back to the owners.
I would not give it back to the owners, because then you're begging them for more money after you just gave it back. So yes, you can put it in reserves. The alternative is you just keep it in the account, because, for example, if your fiscal year ends in December, then in January, if you give back all the money you've got left, you suddenly can't pay your bills in January until people pay their assessments. So my suggestion is either put it in reserves, which my understanding, and I'm not a CPA, but I understand that might avoid any taxation on that being left over at the end of the fiscal year, or keep the money and deal with the tax ramifications so that you can pay your bills in January. But I don't recommend giving the money back to the members, because you thought that that's what it was going to cost to maintain and operate your community throughout the course of the year. So if you're saying, well, we didn't need all of that, then that means that either you overestimated, or more likely you undermanaged. You failed to do certain things that could have been done with the community. I'd rather see you spend that money on beautifying your community and dealing with the landscaping that the previous person that wrote in asked about, than sitting there and giving everyone money back and then having them complain you're not taking care of the paint, you're not taking care of this, you're not doing what you're supposed to do.
Well, we're going to end the show on that note. Alan, I know Alan and I appreciate all these letters that people write in. every week and the phone calls that we get. Alan, you do such an incredible job. You'll be back again with us next month.
Yes,
It's
sir.
always the last Thursday of the month. Alan, give everybody the phone number and your website again.
Sure. The website is www.kbrlegal.com. My email is as@kbrlegal.com. And that phone number is 954-928-0680. Alternatively, 800-974-0680. If you got any questions about community association issues, specifically, legal issues involving your community, please seriously reach out anytime. And Steve, as always,
You're
thanks
the
for
best,
having me.
bro.
Appreciate it.
We'll see you again soon.
Looking
That's
forward to
attorney Alan Schwartzside. He's an incredible attorney with A. Bender Rimbaum. That's it for us today. We'll be back again with you next week. Again, thank you for your questions you wrote in today and the text you write us in every week. If you've got a business and you'd like to come on our show, our phone number is 954-336-3767. We'd love to have you on as an expert. See you soon. Have a good week, everybody.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.